So the question here is, can courts in the UK strike down legislation? The answer is yes in relation to some kinds of legislation, but no in relation to acts of the UK Parliament. So let me explain the circumstances in which there can be strike down of legislation, and then I'll talk about situations where there can't, and think about why it is that at least on an orthodox understanding of the Constitution, there can't be strike down of legislation. And just to be clear, when I talk about strike down, what I'm talking about is a court in effect turning around to Parliament and saying, sorry, you actually aren't allowed under the Constitution to make that law, so we're going to quash it, to strike it down, and to tell you that actually that isn't a valid law at all, because in making it, or in trying to make it, you have sort of stepped beyond your authority and you've done something that you aren't allowed to do. So when can this happen in the UK? Well, it all depends on who it is that's made the law. If it's somebody other than the UK Parliament, then there are situations in which laws can be struck down. Sometimes, for example, government ministers are authorised by Parliament to make laws. We call this delegated or secondary legislation. And if a minister goes beyond the power that Parliament gave it when they make these laws, courts can and do strike them down. Similarly, but it's not the same, but there are some similarities, where a devolved legislature, so the Scottish Parliament or the Welsh Parliament or the Northern Ireland Assembly, where they make a law, they too only have limited powers as set out in the Acts of Parliament that authorise them to make law. And so if one of those devolved legislatures makes a law outside the powers given to them by Parliament, again, the courts can intervene and effectively strike down the legislation that is outside the power. But what about acts of the Westminster Parliament? Now, in relation to the Human Rights Act, courts can look at acts of the Westminster Parliament and they can decide, where appropriate, that they are incompatible with human rights standards. But the most that a court can do in that situation is to issue a declaration of incompatibility. This declares, it says that the legislation is inconsistent with the human right in question, but it doesn't strike down the legislation. Unless Parliament chooses to amend the legislation, or unless ministers exercise powers to amend it, the legislation will continue, notwithstanding that it breaches a human right. There is one exception to all of this, and that is in relation to European Union law, or that there was an exception in relation to European Union law, and there is now an exception in relation to certain aspects of the withdrawal agreement that governs issues as between the UK and the EU following Brexit. When the UK was a member of the EU, European Union law had primacy in the UK, and that did mean that courts could disapply, which in practice is not really very different from striking down, acts of Parliament that were inconsistent with European Union law. The same principle applies now in relation to acts of Parliament that are inconsistent with relevant parts of the withdrawal agreement. So there are very limited situations connected with the EU and now with Brexit where courts can exercise what amount to in practice as to strike down powers. But these, importantly, are powers that Parliament itself has given to the courts. So the question still exists and needs to be answered as to, are there any circumstances in which courts can strike down acts of Parliament other than the situations, as in relation to the EU and Brexit, other than in situations where Parliament itself has authorised this? And the orthodox answer to that question is no. And the answer is no, because Parliament is sovereign, and that means that Parliament can make or unmake any law it wishes. On this analysis, then, there are no constitutional benchmarks, no constitutional limitations by which a court can judge what Parliament has done. If Parliament has unlimited power, because it's sovereign, it can't exceed its powers, and so there can be no question of a court striking down legislation on the basis that it's unconstitutional, leaving to one side situations like the ones I've mentioned in relation to the EU and Brexit, where Parliament itself has directed that the courts do this kind of thing. Now, I said that that's the orthodox view. Is that orthodoxy correct? Is it defensible? Well, in recent years, something which has been very striking is that senior judges in the Supreme Court and before that in the Appellate Committee of the House of Lords have occasionally openly questioned the idea of parliamentary sovereignty. And they have suggested that if Parliament were to do something truly extreme in terms of making a law that was contrary to some very fundamental right or some very fundamental constitutional principle, the judges have suggested that courts may refuse to recognise such legislation as being valid. In other words, they seem to be hinting at the possibility of striking down or at least ignoring legislation that contravenes fundamental rights or principles. But is there any evidence that the courts have actually done this or would do this? Well, here we find an interesting sort of contrast between what the courts do and what the courts say they might do. So on the one hand, like I've just mentioned, there are these occasions where the courts have said that in extreme situations they might be inclined to strike down extreme legislation. But on the other hand, whenever the courts are actually confronted with legislation that they find to be constitutionally dubious in some way, in the sense that it seems to be, on the face of it, to be incompatible with some fundamental constitutional right or principle, what the courts tend to do is to try as hard as they possibly can to find an interpretation of that legislation that rescues it from being a constitutional problem. In other words, a way of reading the legislation that actually brings it into line, at least to some extent, with the fundamental principle or the constitutional right that seemed to be implicated or possibly breached. So the courts really seem to proceed on sort of two parallel tracks. On the one hand, when they're faced with real problems, or what they consider to be constitutional problems, they try to resolve them by interpreting legislation consistently with the relevant constitutional right or principle. And because the court is only interpreting the legislation and telling us what it really means, it leaves, on this view, the principle of parliamentary sovereignty intact. It's not ignoring what Parliament has said, it's just telling us what Parliament meant when it said it. And yet, on the other hand, we do have these judicial pronouncements where courts are saying that if they're pushed too far, if Parliament presses its sovereignty too far, then the courts might say that there are certain things that Parliament isn't allowed to do, and the courts might strike down such legislation. I think that one way of thinking about this is to sort of view it in terms of the courts firing a warning shot across Parliament's bows and saying to Parliament, don't put us in this position, don't test our commitment to parliamentary sovereignty in this way, because we aren't willing to guarantee up front that we would simply go along with what you do, however extreme it might be. And that warning shot, I think, can sometimes have the effect of causing legislators to think again in relation to things that might be in contemplation. And so we have this kind of sort of push and pull where you have Parliament perhaps pressing the envelope in terms of legislating in ways that seem to be problematic in constitutional terms, and the courts push back through this combination of interpreting the legislation consistently with the Constitution and at the same time firing these warning shots across Parliament's bows. The short answer is that we don't know what would happen if a court ever went further and actually struck down an Act of Parliament. But I think the process that I've described of interpretation and warning shots is really the court's way of trying to ensure that we never have to confront that question in the first place. And given that we have an unwritten constitution, given that we have no real roadmap that would allow us to navigate that unprecedented constitutional territory, avoiding getting into that situation in the first place is probably a very sensible strategy.